Start. In the instant case, the review is short on the ground that the petitioner was juvenile on the date of commission of the offence. Stop. According to the learned counsel appearing for the petitioner, it is contended that, as per school records, the date of birth of the petitioner was 1/2/1977. Stop. He was 15 years, 1 month and 7 days old on the date of occurrence. Stop. According to the medical examination conducted on 23rd December 1977, revealed that the accused was 15 years, 2 months and 15 days old on the relevant date. Stop. It is contended that the petitioner could not have been tried by a court other than the juvenile court as per sections 23 and 24 of the Juvenile Justice Act, 1986 bracket open hereinafter referred to as the Act bracket out. Stop. As the trial was conceitedly not conducted by a juvenile court, the whole proceedings were liable to be quashed. It is further contended that the trial court wrongly held the petitioner to be more than 20 years of age, and the High Court erred in not deciding the question of age despite concession made by the counsel appearing for the petitioner. Stop. It is submitted that the counsel of the accused could not have sacrificed the interest of the accused and should have insisted for a finding from the court regarding his being a child or a juvenile. Stop. It is further submitted that the evidence on record requires re-examination, as allegedly there are numerous inconsistencies and contradictions, the benefit of which it is go to the accused. Stop. Though not pleaded, yet the learned counsel argued that as the judgment was pronounced on the same day when the conviction was recorded, the mandate of section 235 of the Code of Criminal Procedure stood violated. Stop para. The grounds urged in the petition and at the bar do not make out a case for review in the guise of this petition, the petitioner has sought the reappraisal of the whole evidence, firstly to hold him not guilty, and even if he is found guilty, to give him the benefit of the act. Stop. The contentions raised and the prayer made are admittedly beyond the scope of review. Stop. This petition can be dismissed only on this ground. Stop. However, being the case of death sentence, we have decided to consider the whole matter in depth to ascertain as to whether the petitioner is entitled to the benefit of the act or not. Stop. We have further opted to consider that even if he is not proved to be juvenile, can he be given the benefit of his age on the ground of his allegedly being on the borders of the age contemplated under the Act for the purposes of awarding him the alternative sentence of imprisonment for life. Stop para. A perusal of the record shows that during the investigation, inquiry and trial, though represented by senior counsel, no plea was ever raised regarding the petitioner being juvenile and the case being governed by the provisions of the Act. Stop. Only at the time of arguments, plea regarding the accused being juvenile was raised. Stop. Over.